we're still early. Nope. Oh, am I live? I am live, and I have been for the last 20 seconds. Okay, cool. So we're starting a little early. And this one's gonna be like a classroom, a law school classroom, just like that's what it's called, multifamily law school. Because this one we're gonna talk about the purchase and sale contract and some of the provisions that I've put into our standard template document that you might want to think about putting into yours. My students get all of this stuff as part of my program. And I always go through my students' contracts. I am not their lawyer, but I act like one. And I always tell you, you must have local counsel because not all contracts, my contracts are not valid in all 50 states. So make sure that you understand that. And that's why you need local counsel. Okay. So the reason why I touched upon this particular topic right now is because one of my students just had a situation occur where she did everything right. She was by the book on the letter of intent and getting it to the seller. And then the seller came back 19 days later, I think she said 19 days later, with a totally revamped purchase and sale contract that they decided they were going to write themselves, and then gave her like a day to think about it. So she and I got on the phone today, and I said, I would totally pass on it. I can't tell you what to do, but in my experience, it's not good. The guy, we had a letter of intent that said we were going to write the purchase and sale agreement, and they decided to flout that. So what else are they going to decide that they don't want to handle? They had taken out all the goodies in there, the protections, and it meant that she was going to violate my number one rule. My number one rule that I teach all of my students. I see people on the call. If you know what that is, put it in the comment box, and I'll know you've been following me. All of my students know what the number one rule is, and what would have happened with this case is she would have been in violation of the number one rule. So why bother? Why bother? Okay. So let me tell you what some of the get out of free jail cards are in my contract. Now, one of them has to do with the distinction between an effective date and an execution date. An execution date is typically the date that the contract gets signed. But we have certain events within the contract pivot off of the execution date, and other dates pivot off of an effective date. And the effective date is essentially a floating date. It is, it is in the hands of the seller. The seller can have the effective date be the execution date, or the seller can never have an effective date, and therefore certain things in the contract will just never get done. And here's what I mean by this. And the reason why I have this is because early on, I would sit there and execute a purchase and sale agreement and then have to wait for the seller to give me the due diligence information that I had asked for. I couldn't wait at putting up my earnest money. You had to get that up right away. But then I had to wait for them to act and get me what I would need to determine whether I will like this property or not. And sometimes they wouldn't give me all the stuff that I had asked for. So how could I cure that problem? And the way I cured it was by saying that my earnest money deposit will go in X number of business days after the effective date. And the effective date, and I'm going to read to you exactly the definition, because under Article 5, the effective date is The effective date for the purpose of determining the time for performance of various obligations under this agreement. The effective date of this agreement shall be the date that seller has provided buyer with all seller submission materials, Article 6, due diligence materials, as detailed in Article 6 of the agreement. An escrow agent has received acknowledgement of such buyer. So in other words, I don't have to put up, because my earnest money says the earnest money deposit section says within 3 business days after the effective date. So the seller gives me all of the due diligence information. I look against the list. He gave me everything. Boom. Today is the effective date. 3 days from now, I can send you my check. So what did I mean when I said at the beginning that the seller totally controls when I put my earnest money deposit check in? Because on the very first correspondence I ever sent this guy, I told him all the things that I wanted. So he's been on notice from the very beginning. I want all of these things. If you can't do it, cross them off and let me know. But if you don't have that information for me when we execute the contract, well, I'm not going to write a check out of my account and send it to some third party. So that's the biggest, that's one of the things that we put into our contract is a distinction between an execution date and the effective date, because we need the seller to perform. We shouldn't be the only one that is performing under this contract. The seller needs to perform. Oh yeah, thank you, Malls. All right, so what's another thing? Okay, the other thing has to do with within 20 days or 10 days after the execution date. So in other words, this is something the seller has to do, not us. We need this stuff, but we want to get it right away. So we don't want to wait until this effective date. So we pin it to the execution date. Oh, there's Ray. Stay in. You know what? I'm in control of what, Ray? Stay in control of your feelings, Ray? Is that what you're trying to tell me, Ray Peters? Stay in control of what? All right. So what we asked for is a survey and also a UCC filing. So in other words, and you say, thank you, sir, stay in control of the deal. The student of mine was no longer in control of the deal. The seller had taken over the purchase and sale contract, and now it was their deal and not ours. Nope, stay in control of the deal. All right, so let me go back to the this UCC and the survey. So in the letter of intent, we tell them they have to turn over a survey. And they sign it and they say, okay, fine. Then it goes into the purchase and sale agreement and we want the survey. We also want a UCC filing. We want to see what other liens and obligations and liabilities exist on this property. So they have to turn that over. Now, the question is, well, what happens if they don't? Well, I mean, we're ultimately going to have to do it. The bank's going to want it. So we should get it to make the determination whether we want to do this deal or not. All right, let me see. Then, of course, I said this submission material. We've already discussed that. Now, let me just say this one thing, and I get this a lot. What you have to understand is that you're not buying real estate. You are not in the real estate business. The property is the factory that generates a product. The product are lease contracts. You are buying a business. And the last item in the list of items we want for the due diligence is the last 12 months of bank statements. We need that. You cannot buy a business. The bank won't even look at the property. You need 12 months of bank statements to document what has gone on. Because what you're doing when you're going into the due diligence, the financial due diligence process, you're essentially rebuilding a pro forma model of that business. And you have to start with the top line. And from the top line, that's when you're going to be able to figure out, is this property what they sold me? And the top line is revenue, gross revenue into a bank account, and the bank account statements are independent third-party documentation of exactly how much was collected. And so that's where you're going to start from. So if they come back and they say, oh, I don't have that, I commingle accounts, or like, yeah, well, I got this, I do 3 or 4 properties in this one. Like, oh no, listen, I use it like it's an ATM machine, and I can't get, tell you exactly how much there's. Listen, I don't care. I don't care. You do and can separate out the deposits, and you can show me which deposits came from which properties. You want to know how I know? Because I know your accountant wouldn't sign off on the tax return if he couldn't verify that information. So give me what you give your tax accountant, and I'll work with that. So we always put that one on there at the bottom. All right, next one is, all right, so this one is, let me read to you this next get out of free jail card. There are actually 2 of them, and they're good ones. And I put them in here from years of experience. Until the closing, the seller shall not sign a new lease or renewal for a period longer than 12 months, or for an amount less than the stated market rent, and shall maintain fire and extended coverage casualty insurance on the property for its replacement cost. Should a change in occupancy occur which is greater than 5%, the seller shall notify the buyer immediately, in which event the buyer shall have the option to terminate this agreement and receive a return of the earnest money. At no time shall security deposits be applied to rent or any other fees or charges due from resident. No lease shall be executed without a fully completed and signed application credit report, and no concessions shall be given for rent or deposits. Oh, let's unpack this, because this has got a whole bunch of really good stuff in there. So let me go through this again. Remember, should a change in occupancy occur which is greater than 5%, seller shall notify buyer immediately, in which event the buyer shall have the option to terminate this agreement and receive a return of the earnest money. Okay. It's the seller's obligation to notify, to report any changes of occupancy which is greater than 5%. The change is greater than 5%. The seller has to notify, and I get to decide when I can cancel that contract, when I can get my earnest money back, when I can walk from the deal. Notice that it doesn't say this has to take place during the inspection period. The way I've worded it is I can take it right up until the day of closing and decide I want out because the occupancy has changed by more than 5%, and I get my earnest money back. How many times have you heard the expression, your money's hard? Yeah, your money's hard. Well, yeah, unless you've got get out of free jail card provisions in the purchase and sale agreement like this one. Okay? How would you feel if you had that provision in your contract? Security deposits cannot be used as past due rents. Oh, this is a good one, because they tried to pull a fast one on one of my clients one time, and they said, hey, yeah, we're at the closing table and we got a problem with the HUD statement. What's the problem? Well, there are no security deposits because you let the tenants use them for rent. You mean I'm taking over this whole business and I have no security deposits on file because you just decided to pay yourself this rent? Yeah, that's exactly what we did. Well, it's too bad, because I got a provision in there that says you can't do that. And on this particular deal that we were doing, it was one of those types of mortgage companies when they were, released the lien. The mortgage company would only close on the 5th day of a month. And if we didn't close that 5th day, the seller would have to wait another month to get his money. Oh, he did not like that. And he did not like that I wrote the contract and knew it and knew that he couldn't do that. So right at the closing table, they had to credit that back over to us. That was fun. Credit report. So you have to do a full credit report. So we've got all of those provisions in there. Now, the thing that I don't have, and what you might want to do is all of these things, if the guy doesn't do it, you always have to ask yourself the question, so what? So what? So what the guy did that? So what? Well, we have grounds for terminating the contract in here. You might want to think about different types of provisions to penalize the seller. You'll see what I mean in just a moment. Get a load of this one. This is the next one. All appliances, fixtures, and equipment relating to plumbing, heating, and cooling, electrical systems, and any other equipment or system shall be in normal working order at closing, ordinary wear and tear accepted. No fixtures or appliances shall be removed from the property after the time of closing unless otherwise specified herein or unless vacated within 48 hours prior to closing. Any units vacated within 48 hours prior to closing shall be reported to buyer prior to closing in sufficient time to allow a final inspection of the vacated units by the buyer. All said vacated units shall be in rentable condition with the exception of normal cleaning requirements or appropriate adjustments shall be made to place the units in rentable condition. Other contracts, other purchase and sale contracts, we put actual teeth into this provision that said that if the person didn't report, they were going to owe us $2,500 per unit to turn that unit. So we actually put a dollar figure in there as a penalty for failure to comply. Now, let me tell you why this provision came about. We had a long closing. It was this was a new money purchase. So it was just a longer closing. And, the occupancy stayed stable all through the contract period. When we took over that property, man, there was nobody there. And no units had been turned. And no units had been reported as vacant. It's like overnight, everyone moved out. Well, it didn't happen that way. It's just the seller didn't want to manage the property. And somebody moved out. He wasn't going to fill it. So he just wanted his money and he ran. Hey, Darren, good to see you, man. So that's why we have that provision in there. And that's why you always want to do a walkthrough just before closing. Now, remember, we have wording in this contract that the inspection period, it's under Article 8, the inspection period can it takes place throughout the whole contract period. All right. In other words, I have 30 days to back out and get my earnest money back because of the inspection period, but I get to inspect the property at all times, usually 24-hour warning, at all times prior to the closing to make sure that everything's going well. I'll tell you something, folks. The deal that we're doing right now, two of my partners went out and did that, and as a result, they found something was very wrong with the property, and we had to postpone the closing. And it was a good thing because that would have been a huge problem. Okay, so now, another provision we have in here is in the financing period. We put in there specifically certain terms regarding the quality of the loan or the benefit of the loan, so that we protect ourselves. So let me read it to you. In the event the buyer determines before the expiration of the financing period, the buyer is unable to obtain financing with no less than 80% loan to value. Okay. So right away, I'm telling them, hey, the only way this deal is going to work for me is if I got an 80% LTV. Well, in today's day and age, that's a lot harder to get. Banks are being very conservative. So if it's a local lender, I don't think I'm going to get an 80% LTV. So that is a point in there to say, hey, sorry, I can't get an 80% LTV. so you can walk. Now, that's one way of writing it. Another way of writing it, depending upon your negotiations with the seller, is that, hey, I have to be able to get a loan that it satisfies my requirements. Well, what's that? I don't know. It could be anything, but we're going to keep this as broad, so broad you can drive a Mack truck through the provisions. And if I don't like what I get, I'm going to walk. So that's one way of also writing the financing provisions so that you give yourself a pretty big out. This particular contract that I'm flipping through right now, actually is a loan assumption. And if you're doing a loan assumption, that's a totally different animal. And you've got to add provisions in the purchase and sale agreement. They're actually provisions that are in your letter of intent. They have to show up there. If they don't show up there and you try to slip them in the purchase and sale provision, it's bad form. It's just bad form. So, make sure that comes into play. So you always want to have those four, I think 3 or 4 provisions I put in there for a loan assumption. I'm not going to get into them right now. That is not a get out of free jail card. That is required of any type of an assumption. Okay, let me see. I took care of that one. Let me see. I took care of that one. Okay. Let me see. I got a couple more. Bear with me. Okay, so let me just talk to you about, so everybody understands what happens if there's a breach. What happens if one of the parties breaches? Now, I'm not going to talk about the buyer. If the buyer breaches, he loses his earnest money. If the seller breaches, what are the remedies? Typically, you have 2 remedies for a seller breach. One of them is specific performance, where you go and you sue them to sell you the property. That's one way of doing it. The second way of doing it is the seller breach is you just get all your earnest money back. So those are typically the 2. Now, sometimes the contracts are drafted so that they only have one, and that's just the return of the earnest money. I mean, think about it. If you're dealing with a specific performance and the guy can't close, maybe he just, for some reason, he cannot physically close in that property. He doesn't have the money. He has to come to the table with more money, something like that. Those are some of the things that we have to deal with. All right. Now, I'm just going to tell you about one final thing, and that will do it for us today. Now, the last thing is this thing of recording the contract. Okay. Now, if I'm selling the property, I want a provision in there that says no recordation. It's the no recordation provision. And that means that I can't take this purchase and sale contract down to the registry of deeds and, witness my signature and record it against that property. That's what that's what a no recordation says. And if I'm selling the property, I don't want the buyer to be able to do that. If I'm buying the property, I do want a recordation provision in there. And in this particular case, we've drafted it such that it's called a memorandum of contract. The buyer may prepare and record a memorandum of this agreement at its sole cost, and seller will sign the same. Okay? So why do we need that? Well, first off, a purchase and sale contract is an interest in land. So therefore, it can be recorded at the registry. I can take this purchase and sale contract, fully executed, down to the registry, and I can record it. And by doing that, what I've actually done is I've clouded the title of the property, and now the seller can't sell it out from underneath me. And if he and I get into a dispute, well, he's not selling that property until I've released him. All right. So I have control. All right. So that is what the recordation is all about. Now, Here's the rub, and this is where you'll see this in Texas all the time. Notice that the name of the provision that allows me to do this is called a memorandum of contract. What's a memorandum? A memorandum is nothing more than a one-page document that you go down and register at the registry, letting the world know that there exists some contract. We're not going to tell you or show you what the terms of the contract are because that's private between us. But we are going to let you know and let the whole world know that, hey, Mr. Buyer has a right to that property. And I'm letting the world know by just drafting a one-page memorandum document. It'll say memorandum of contract. And if you go to Texas, and the reason why I'm just picking Texas out is because Texas is a non-disclosure state. So that's what happens in Texas. You get a mortgage on a property. Well, you don't want the assessor's office to know what your mortgage amount is, because then they can back into a purchase price, and then they can tax you at that new valuation. Remember, it's a non-disclosure state. They don't want to disclose, but we have to let the world know that we have a mortgage out there. So we do a memorandum of mortgage, memorandum of lease, memorandum of contract, all of these things to put the world on notice. And that's why we have that recordation provision in the contract. If we're buying it, we want it. If we're selling it, no, don't do it. Don't do it. So that is it. I hope that was helpful to all of you. This is, I tell you, make sure you read. All of you should read the purchase and sale contract and understand what your duties and obligations are under that contract and what the other party's duties are. And if you don't understand it, ask for legal advice. Okay, this is your business. If you're writing, a check personally, well, it's your money and you could lose it all. If you're using other people's money, well, you better know. So let's get that figured out. And make sure you know what you're doing. Make sure you understand the contracts and write offers. It's the best advice I'm closing with. Write offers. All right, everybody. Hey, I've got something coming up on Saturday. I was just told. I'm not quite sure. No, I'm sorry. It's for a closed group. It's for a closed group of my students. Where I'm going to be teaching, I think, for about 2 hours, and it's going to be it's just going to be a straight up training session on an overview of multifamily property. Okay, so that's that, and I will see you all. Next Tuesday. Listen. I think Molly's going to tell me that I haven't read my email yet, and the guy is not available next week, or maybe he is. I don't know, but one of these upcoming YouTube lives, we are going to have a special guest showing his new company's program, which is cool. Yeah, so we're gonna get that out there and show it all to you. It's gonna be fantastic. All right, everybody, great to see you all, and we will see you next week. Thanks, everybody.